Today on Bench Briefs, we're looking at a landmark decision from the Supreme Court of Canada that tackles the tricky intersection of digital privacy and police powers. In R v. Tessier, the court wrestled with how constitutional rights apply when the police search and seize digital devices, a question that's more relevant than ever in our tech-driven world. So, what happened in this case? Mr. Tessier was charged with criminal offenses following a police investigation. The police obtained a warrant to search and seize digital devices, think smartphones, laptops, and other electronics, that might contain evidence related to the alleged crimes. The warrant authorized the search and seizure, but the way the police executed the search and handled the digital evidence raised important questions. Was the search conducted reasonably? Did the warrant properly limit what the police could look for and seize? And crucially, were Mr. Tessier's rights under the Canadian Charter of Rights and Freedoms respected? At its core, this case is about privacy in the digital age. Digital devices store an incredible amount of personal information: pictures, messages, emails, location data, and the law is still catching up with how to protect that privacy when the state seeks evidence. The Canadian Charter guarantees protection against unreasonable search and seizure, but what does unreasonable mean when it comes to digital searches? And how detailed must a warrant be to ensure it doesn't give the police a blank check to rummage through someone's private life? The court had to look closely at the scope of the warrant. Warrants need to be specific. They must clearly state what can be searched for and what can be seized. This is even more important with digital devices because of how much information they hold. If a warrant is too broad, it risks violating the charter by allowing an invasive and unjustified search. The court also considered how the police actually conducted the search. Even with a valid warrant, the manner of execution matters. Did the officers stick to the authorized scope? Did they take steps to minimize privacy intrusions? And was the evidence handled properly to protect Mr. Tessier's rights? In R v. Tessier, the Supreme Court reaffirmed that constitutional protections apply robustly in the digital context. The court emphasized that digital searches require careful judicial oversight to ensure warrants are precise and justified. It also highlighted that police must follow strict protocols when searching digital devices to avoid overstepping constitutional boundaries. If those safeguards aren't met, the evidence obtained could be excluded, which means it cannot be used in court. Why does this matter beyond Mr. Tessier's case? As our lives become increasingly digital, the law must strike the right balance between effective law enforcement and protecting individual privacy rights. This decision sends a clear message. The Charter's protections are alive and well in the digital era. Police can't just seize and search devices willy-nilly. They need clear authorization and must respect privacy standards. This sets a precedent that will guide how courts handle digital evidence in the future, impacting not only criminal cases, but also broader discussions about privacy, technology, and state power. Thanks for listening to this episode of Bench Briefs. Tune in next time for another deep dive into the cases shaping Canadian law.